We'll start the morning with People versus Payton Thompson, file 226944 SM.
Morning, Your Honor.
Good morning. Mr. Thompson appears this morning along with his counsel, Henry McRoberts. The prosecution appears by Assistant Prosecutor Alex Zeminski. We're set today for sentencing. Mr. McRoberts, did you have a chance to go over the pre-sentence report with Mr. Thompson?
I did, Your Honor, and there's nothing of a factual nature to correct on here today.
All right, is there anything in general you wanted to say on behalf of Mr. Thompson before the court imposes sentence?
I will, Your Honor, but before I start, I've advised Mr. Thompson not to make any comments at the hearing. It's not to be disrespectful. It's just because I believe civil litigation is imminent. He has entered a no contest plea, which means he has taken responsibility for any role he had in the incident. Payton's a young man, recently 21 years old. He has potential. He has maintained his employment. He has family support. I didn't have a whole lot to say about at sentencing because, as the court's aware, we had a Cobb's hearing in December where the court reviewed the recommendations and stated for the most part the court was on board with those. However, I was provided late in the day on Tuesday a large amount of documents, including a letter from the victim's family regarding Mr. Thompson as well as Mr. Pellegrini, that sort of brought up some issues that I don't think are appropriate for sentencing. They tried to allege that Mr. Thompson has violated his bond numerous occasions, which is completely untrue. And I just wanted the court to be aware if the court is considering those that correspondence or the attached documents, I wanted to address that. I believe the whole tenor of the letter was an effort to once again attack Mr. Thompson and criticize the court's handling of this matter. They raised past transgressions when Mr. Thompson was in high school, and they also attempt to speculate on how he will behave in the future when on probation. There's no indication that Mr. Thompson is going to violate his probation. He is a young man. I'm confident he's learned from this entire experience. As I've heard the court state on many occasions, a young man or woman's brain does not fully develop until later in life. I mean, Payton has made mistakes, and I'm sure he's the first to admit to that. But he is, I believe that he is taking this seriously. He has his fines and costs to be paid in full. He is aware that he's going to be responsible for restitution. There's also an attack, and this has been a theme throughout these whole proceedings where they indicate that Mr. Thompson and the co-defendants should have been charged with felonies and that they're getting a break from the court. Mr. Thompson was charged in this matter at the discretion of the prosecutor. He was not given any type of plea deal. He entered a no contest plea to the charges as charged. I just believe that there's no place for this type of information in the sentencing. I'm asking the court to fashion a sentence based on what has transcribed, what has been this incident and the probation court's the probation department's recommendations. There's also allegations about the incident that are in there that are fully false. It states that Mr. Thompson stomped, kicked. The evidence in this case is very clear that based on the statements that were given that Mr. Thompson, the primary allegation against him is a punch or punches, there's no indication of stomping or kicking. Are punches excusable? Not. They are not excusable, but I don't believe the court should consider extraneous information from the victim's family making allegations that is not supported by the evidence. More importantly, there's indications about bond violations in this case. I know there have been bond violations by other individuals, but Mr. Thompson has not violated his bond. He has been maintained his employment and working towards putting this matter behind him. The recommendations are appropriate, Your Honor. We had the Cobb's hearing in this matter. He's going to be sent to jail. The court follows these recommendations for 30 days. He's ready to go today. He's going to be on probation for 12 months with no early discharge. He does have fines and costs, in which I've indicated he is fully able to pay today, which shows that he has taken responsibility and is taking this matter seriously. This incident will not define Payton. As I told him, he's a young man. He can grow from this or he can fail. If he's going to be on probation for a year, there's going to be many people watching him. And if he violates his probation, the recommendations are quite clear as to what can happen. But I'm confident he will not do that. So I'd ask the court to sentence Mr. Thompson in accordance with the recommendations that were dated or updated by the probation department in December of this past year.
All right, then, Mr. Szymanski, is there anything that you would like to say or one of the victim would like to say in this matter?
I believe Ms. Danielson would like to speak, Your Honor, but first I wanted to address, and I believe it was brought to the court's attention as well as Mr. McRoberts this morning. The restitution amount needs to be adjusted down by $140. It was brought to our attention. It's our office's mistake, and I apologize to the court for that. One of the bills, it indicates a total, and then it indicates an additional discount for a payment in cash of 5%, and that's where the $140 comes from. So I would be asking the court during this sentencing and the previous sentencing, and our office will certainly do whatever it takes to adjust the previous sentencings to reflect that $140 difference. So I do apologize to the court. I think in all fairness, that needed to be addressed.
Thank you. That was brought to my attention by the probation department yesterday or the day before. I believe it was brought forward to the defense counsel as well. So we can address that today concerning the sentencings that are on for today. Concerning the 3 that have passed, I've directed the probation department to rectify the restitution amount in regard to those files. In regard to the issues brought forward by Mr. McRoberts concerning the extraneous information, Ms. McDaniels, have brought forward a lot of information over the course of each of these sentencings. I think what you're referring to then, Mr. McRoberts, if I want to be clear, what I received was a letter that was received by the court on the 14th, typewritten, 2 pages, signed by Ms. Danielson. There was some a copy of a police report dated April 1st, 2022, supplemental April 9. I believe that's redundant of earlier reports that had been received. Then there were some copies of texts, which I believe were redundant of the photographs that were received of various text messages. Is that what you're referencing?
Yes, there was a letter, photographs, and then the main primary concern was some of the comments in the letter, as well as there's numerous texts that were not even entire text threads, but that were included in that information that didn't relate to the incident at hand.
And I would note for the court, our office was aware of the letter in the process of serving that letter on the parties. We became aware of some more stuff that was turned over to the court's file. Our office took it upon ourselves to copy all of that information and provide it to counsel. Just in an abundance of fairness, whether or not the court was going to consider that information or review it or alter its sentence in some way, I felt it imperative that it be shared with all the parties.
Right, so Ms. Danielson came to the window the other afternoon, and we've instructed her in the past that she needs to bring the information to the prosecutor's office so that it can get disseminated properly to the parties and not just the court, wherein the response was she had. And then shortly thereafter, it came to light that all of these photographs of various text messages had not been provided to the prosecuting attorney's office, at which time we did contact their office. You took those and took responsibility for getting them to defense counsel. So there is a process, Ms. Danielson. When we tell you these things, it's for a reason. In regard to the matter, then, I've had the photographs here of Mr. McWilliams, these are, again, duplicitous of other things that I have seen before. As far as the text messages are concerned, I've reviewed them, Mr. McRoberts, Mr. Saminsky. There's nothing in there nor in her letter that is really frankly anything new from, I mean, they all turn a little bit on depending on the individual, but essentially the same theme. Mrs. Danielson has been advocating on her son's behalf, and there's nothing contained therein that would cause me to digress from the agreement, the Cobb's agreement.
Thank you.
So in respect to your position, does Mrs. Danielson or anybody else want to say anything here?
I just have some brief comments and then I would turn it over to Ms. Danielson.
All right, please.
Your Honor, as the court is aware, this is, I believe, the fourth sentencing before this court on this same criminal incident. The court is certainly aware of the facts of this matter. In addition, the court did hold a Cobb's hearing to go over this very sentencing. So I believe the sentence is appropriate. I would ask the court to follow what was recommended at the Cobb's. It's consistent with Mr. Thompson's level of culpability and with what the other co-defendants received. So I would ask the court to be following that. By and large, I'm going to leave any further comments about the facts of the case to Ms. Danielson. She did provide this court a letter. She has been a zealous advocate for her son, and certainly she knows the facts better than I ever could and the effects that have had on her son. Certainly the court is aware of those effects. They've been before this court in multiple other sentencings. And I believe the sentence that is laid out in this pre-sentence report is crafted to address all of the appropriate punishment, rehabilitation, and social deterrence. So I would ask the court to follow the sentence. Thank you.
Thank you. Ms. Danielson, would you like to address the court? Could you hold on a minute while we get the, there we go. Please state your name.
Sandra Danielson.
Thank you, Ms. Danielson. Floor is yours.
Mr. Thompson, from the assault that you and your friends did to Trenton, he received broken teeth, a broken septum in his nose, lacerated eyelid, holes in the top of his head from Mr. Zanone's steel-toe boots that were admitted in his Cobb's hearing as well. Blueprints and bruising all over his body. His lower back was black from bruising. His neck had bruising and boot prints on it. His head was swollen and he had large knots on his forehead. The concussion will last indefinitely, per the neuropsychologist. He now has PTSD and his memory and cognition have decreased, and it was bad enough before due to his disabilities. You and your friends not only made this plan, but you carried it out, and then you all left. You're a coward. You had all your friends join in on this attack. When you assaulted my son, you were on probation for malicious destruction of property. You had also been arrested for underage drinking in Marinette, Wisconsin, while you were on probation. That is why I feel, Your Honor, that he won't follow his terms of probation. And being as there has not been any consequences for those 2 violations, I don't see that he's going to follow the rules. People from this community, Your Honor, have approached me and told me about their own experiences dealing with Mr. Thompson and his group of friends during school and after school. They're afraid of retaliation. Their names have been given out to the defense attorneys and to the defendants. And these people are worried They were willing to come forward and testify had there been a trial. Our children in our community need to feel safe. Friends of mine have told me that now kids are saying they're going to go jump this person or jump that person. I don't know that it has anything to do with this case, but when that is going on in school, to allow these individuals to just get a little bit of punishment, which I don't expect a whole lot. 30 days would be sufficient if they were sitting back in jail. When kids are acting out like this in school and they're not disciplined in school, as Mr. Thompson and his friends weren't, this is what happens. I just hope that the court can make it clear to the public and keep our community safe. Make it clear that this is not acceptable in our community. Thank you, Your Honor.
All right, thank you, Ms. Dennison. Mr. Thompson, anything you'd like to say?
I would just like to apologize for taking up the court's time. This has been a long process, and it would be my apologies to the whole court and everybody involved.
All right, Mr. Thompson. Well, concerning the matter, Ms. Danielson is certainly right in most every respect as far as the appropriate and inappropriateness of the behavior, the group mentality, the injuries, the picking on people more defenseless. And I seem to get the gist. If I understood where it really went awry was some comments that were made about your mother that caused you to have certain amount of anger, and back and forth we went. And life is going to be full of those moments when somebody's words or thoughts or actions get you angry, but the response is completely inappropriate. And I hope you understand that, because she is right. People need to feel safe. They need to feel that other people, part of the scheme of sentencing, or what has been set up by the founders of the law, are the purposes of sentencing. First are to punish the individual, first and foremost, that has committed the wrong. Part of the scheme requires that the individual suffer consequences that deter other people, or make other people not want to engage in that because of the consequences that are suffered by the individual that is getting sentenced. The sentence is designed to protect the public and to try to rehabilitate the individual involved in the wrongdoing. And so in this particular case, or in these cases, to a large extent, sentencing is individualized, meaning, not everybody that comes before the court is in the same shape. Some people have been here before, some people have never been here before. Some people are more responsible in their particular acts than other people. Sometimes there's extenuating factors that make things worse. So we have to try to individualize the punishment for the individual that is before the court and the circumstances for which they find themselves before the court on a certain continuum. And as I've explained in the past here to Ms. Danielson, who has been a very good advocate for her son, she, the way that the system of justice is set up is that the function of a jury is to determine guilt or innocence. They are the triers of fact. And so in these particular cases, there have not been jury trials, but a jury could have done no more than to find you guilty of everything that you pled no contest to. So essentially, the function of the jury was fulfilled in that there was a finding based on the charges contained in the complaint. The system is set up so that there are different branches of the law that handle different portions of the case. The charging is the function of the prosecuting attorney. They get to decide what charges appear to be appropriate, fair, and just under all of the circumstances. They have decided on these aggravated assault and wearing a mask to decide or to commit the crime. And so the courts have the discretion about imposing a sentence that is appropriate within the limits set by law. And the legislative branch determines what the maximums are. Here on the assault aggravated, maximum 1 year. In regard to your particular position, you have found yourself before this court. You were on probation to this court on a malicious destruction at the time and on a delay of sentence. That delay of sentence was never lost because as the case progressed, apparently it must have taken some time to investigate. And by the time it went to the prosecuting attorney and the charges were issued, you had already been dismissed from probation on that malicious destruction and received your delay of sentence. And part of what I have explained in the past in other people's cases is that in general, if a person comes before the court with no prior criminal history, no brushes with the law, generally they are entitled to an opportunity to demonstrate that it was an error in judgment not likely to be repeated and get the benefit of establishing that it is an error in judgment over the course of a probationary period, at which time the charge could be dismissed under the delay of sentence. And I know it doesn't seem enough when you're sitting in the position of Mrs. Danielson. Nothing is enough for the pain that she's seen her child suffer, for the aggravation and pain that she's suffered herself, her family members, and all of the stress and agony that they have gone through based on the actions that you, Mr. Thompson, and your cohorts decided were appropriate on the night in question. They were inappropriate. I think you're very well aware of that now. I think you'll be exceptionally aware of it by the time you get done serving 30 days in jail. It's not going to be a pleasant place to be. And remember that, so that in the future you make better decisions. You're capable of making better decisions. You'll have to make better decisions because it's time to move on. You're 21 years old now. You're employed full-time. Looks like you have a good job. So make sure that this is a learning experience. Make sure that you do what you can. As I look at these photographs of Mr. McWilliams and the damage that was wrought, it sends shivers down a person's spine that you could be so careless and so cold. I don't know what else to say. Careless and cold. In regard to the matter, then, I'm not going to grant you a delay of sentence for the reasons stated at the Cobb's hearing. You had that opportunity. In respect to the matter, I'm going to impose probation for 12 months. There will be no early discharge from probation. There's a $400 oversight fee for probation. Fines and costs on count 1 are $640. Fines and costs on count 2 are $440. In respect to restitution, 2973, I believe is the correct number. Is that right, Mr. McRoberts?
It is with the sheet I received this morning.
2973 jointly and severally with the other co-defendants and the juvenile. In respect to restitution, any other amounts remain subject to hearing. Crime fund fee is $75. There are 2 justice system assessment fees, each in the amount of $50. $1,655 in fines and costs plus restitution. Did I hear you say he's going to pay the $1,655 in full today?
Correct, Your Honor. He'll be going to jail, so I don't know if the court wants him to pay it from the jail or upon his release, whichever's easiest.
Well, he can pay on the, would you prefer to have him stop on the way down or on the way
You can do it on the way there.
All right. I'll order that be paid in full today. In respect to restitution, then it's about $425 apiece. Mr. McRoberts, some of the co-defendants have paid more than their share. I think the defense attorneys are gonna need to speak with each other as well as through probation to figure that out, but so he's gonna owe about 425 in restitution.
Once I have that conversation and everyone's in agreement, I'll pass a number along to Mr. Thompson. I'm confident he'll pay it quickly.
All right, then I'll order that be paid over the course of probation. And I'm gonna order that, well, actually, I'm gonna order that 425 payments start on that 30 days after release from jail at 150 a month. I'm gonna order 90 days in jail, 30 days beginning now with credit for 1 day served. 60 days will be suspended for successful completion of probation. Well, she has suspended here. 60 days, we can say held in abeyance for successful completion of probation. In addition to the general terms of probation, the following are specific. You must absolutely abstain from the possession or consumption of alcoholic liquor in any form whatsoever. You may not use, possess, or consume any non-prescribed controlled substances or prescription medicines that aren't prescribed to you. You must avoid all people that use, sell, and possess those items. Recreational marijuana use and possession are prohibited until further order of the court. You are subject to random PBTs and drug screens. I'm going to order that you attend and complete an anger management class. You may not engage in any harassing, intimidating, assaultive, or threatening behavior with any people. You are not to possess or use social media while you're on probation, including but not limited to Snapchat, Facebook, Instagram, Twitter, etc. You are not to be on the property of W5678 Swede Lane, Norway. No contact with Trenton McWilliams. You understand the terms of your probation?
Yes, Your Honor.
All right. Did you understand the advisal concerning your appellate rights?
Yes, Your Honor.
All right, Mr. McRoberts, anything else?
No, Your Honor, thank you.
Mr. Saminsky?
No, Your Honor.
All right, then, good luck to you, Mr. Thompson.